Facts. Leonora and Rodora filed a joint affidavit complaint against petitioner and Arcebino before the Office of Provincial Prosecutor Felix T. Cabading of La Trinidad Benguet. After preliminary investigation, petitioner and Arcebino were charged with the crime of violation of Section 68 of PD 705, otherwise known as the Revised Forestry Code of the Philippines. After trial on the merits, the RTC found petitioner and Arcebino guilty as charged. Petitioner and Arcebino filed a motion for reconsideration, which was denied by the RTC in its December 1, 2009 order. The Court of Appeals affirmed with the modification that appellant Edwin Talabis is hereby sentenced to suffer the indeterminate penalty of imprisonment of 6 years of prison correctional as minimum to 10 years of prison mayor as maximum. Petitioner thus sought reconsideration of the January 16, 2014 decision of the Court of Appeals. In his motion for reconsideration, petitioner imputed error on the Court of Appeals for its failure to appreciate two mitigating circumstances of voluntary surrender and old age in modifying and imposing the proper penalty against him. The Court of Appeals denied petitioner's motion for reconsideration, rationating that the two mitigating circumstances mentioned in the instant motion were never raised by the appellant during his trial as part of his defense. There is thus no compelling reason to modify, reverse, or set aside the appeal decision. And the third, the petitioner filed the instant petition. The issue in this case is whether petitioner is entitled to the mitigating circumstances of old age and of voluntary surrender. The ruling, petitioner is not entitled to the mitigating circumstance of voluntary surrender. Petitioner filed his motion for reconsideration of the January 16, 2014 decision of the Court of Appeals, where, for the first time, he brought to the attention of the Court of Appeals the mitigating circumstances of voluntary surrender and old age for the purpose of modifying and imposing the proper penalty against him. As his motion for reconsideration was denied, petitioner now imputes fault on the Court of Appeals for not appreciating the two mitigating circumstances in his favor. The Court of Appeals was correct in refusing to take cognizance of the belatedly raised issue of whether or not petitioner is entitled to the mitigating circumstance of voluntary surrender. It is well settled that no question will be entertained on appeal unless it has been raised in the proceedings below. Points of law, theories, issues, and arguments not brought to the attention of the lower court need not be considered by a reviewing court, as they cannot be raised for the first time at that late stage. Basic considerations of fairness and due process impel this rule. Thus, if such mitigating circumstances were considered by the Court of Appeals, or the Supreme Court for that matter, the prosecution would be denied due process as it would have been denied the opportunity to present evidence to disprove that petitioner did surrender spontaneously and voluntarily to the authorities. In any event, issues raised for the first time on appeal are barred by estoppel. Failure to assert issues and arguments within a reasonable time warrants a presumption that the party entitled to assert it either has abandoned or declined to assert it. Accordingly, the supposed failure on the part of the Court of Appeals to appreciate the mitigating circumstance of voluntary surrender in petitioner's favor cannot now be raised as an assignment of error in the present petition.